video is going to cover slides 12 and 13. So I want to start off by talking about what's on slide 12, the position of the American Psychological Association and what implications this has for the legal system. So the first thing I want you to do is click on the link at the top of the slide, and that should take you to I'm trying to do it now so I could take a look at it. That should take you to the APA position at the present time on repressed memory. What does the American Psychological Association have to say about trauma and repressed memory versus false memory? So if you go, it will take you, if you hit that link, it will take you to the American Psychological Association, Memories of Childhood Abuse, and they ask, can a memory be forgotten and then remembered? Can a memory be suggested and then remembered as true even though it's false? This is at the heart of the memory of childhood abuse debate. And I want you to take a look at this because on the APA site, what they essentially wind up saying is that number one, there is a consensus amongst most experimental psychologists in the field of psychological science who research this topic that most people who were sexually abused remember all or part of the abuse and do not repress it. Now, whether or not a true repressed memory can occur, as opposed to a pseudo-memory, as it's called, or a false memory, the final answer, they say, is yet to be known. Now, it's rare according to the research to date. And remember, experimental psychologists approach any phenomena from a nomothetic perspective. They say, let's measure large groups of people and see what most people do, and that's what we are going to accept as valid. In this case, most people studied who've experienced something traumatic, something difficult, remember it, and it is very easy, the research shows, to implant a pseudo-memory or false memory in someone's mind and convince them that it is true. They talk about what further research is needed to really settle this controversy once and for all over the validity of memories of childhood abuse. They talk about whether or not this controversy should prohibit people from seeking treatment. And what they come to, the APA decides, look, yes, there's been sensationalization and over-reporting of repressed memories. There have been media portrayals and entertainment portrayals that have led people to believe this is much more common than it actually is. But having said that, people who think they have some kind of difficult issue that they need to overcome, it could be from their childhood, maybe not, should nonetheless seek help. What they do say is you should look for particular credentials as well. And some of this has to do with the licensing of that individual, the level of education that person has achieved. It is also helpful to seek out treatment from someone who utilizes the scientist practitioner model and actually consults the research on memory when moving forward with treatment. So I do want you to take a look at that APA site that I've given you here and take a look at what the APA has to say about the debate over pseudo-memories and repressed memories. All right, now the next question for our purposes here in a forensic class is, should information about this memory debate be presented in court when something like the Shanley case, the one I told you about on a previous video, where a Catholic priest was accused years later of sexually abusing an individual when he was a child? Should information be allowed in court about the repressed memory debate? And then the question is, what? Should the court allow clinicians who believe in and treat repressed memory to serve as expert witnesses and convince juries that this can happen? Should the court allow expert witnesses in the form of memory researchers, experimental psychologists, to talk about the dangers of false memory and pseudo-memory implantation? Should both be allowed to testify as experts and let the jury sort out which seems like a more valid argument, or should neither be allowed to get involved because it will confuse jurors and bring a controversial, unresolved psychological debate in science into the courtroom and create difficulty, and confusion. I want you to think about that as you're moving forward with this video that I'm presenting to you now for these next 2 slides. So ask yourself the question, should nomothetic research prevail, where an experimental psychologist who has studied large groups of people presents what the research shows most people do? And that, of course, would be what? That would be that the research shows it is easy to implant pseudo-memories or false memories. It is difficult to know whether a given memory an individual claims to have brought to consciousness actually happened or was suggested in some form. Whether it was confabulated, I told you what that means, people fill in gaps. Or should the court allow predominantly clinical idiographic approaches where they talk generally about their own cases with their own clients who have come to them for what appears to be a repressed memory of sexual abuse or physical abuse? And should the court allow that idiographic case-based approach of individual clients who had recovered memories, supposedly, and have been treated? Should that be allowed? Now, here's another question to think about. Should the ordinary, what is called statute of limitations and delayed discovery rule be permitted on the basis of a repressed or recovered memory? So what does this mean? Now, I'm going to direct you to some links in a minute that I want you to take a look at, but let me give you a general sense of what a statute of limitation is. You hear the term limitation, you know what that means. There's going to be a time after which something can no longer be done or pursued, right? A statute of limitation, you probably heard this term somewhere, is a type of federal or state law that restricts the time frame within which a legal case or proceeding can be brought to the court, okay? And most crimes have statute of limitations with some exception. Delayed discovery is linked to the statute of limitation in the sense that delayed discovery is a legal rule, a legal doctrine, a law that suspends the statute of limitation, so it stops it. It suspends the statute of limitation during periods of time where the plaintiff, now in a civil case, the plaintiff is what we call the individual suing. In a case where somebody alleges that he or she has been harmed in some way in the past and is remembering it now, we could have what are called delayed discovery rules, where the statute of limitation stops. It's sort of like stopping the clock. And this is stopped during periods of time in which the plaintiff did not, or even if that person exercised reasonable diligence, as it's called, meaning they've done whatever they could possibly have done to discover, could not have discovered the necessary information or the injuries that would have led that person to seek a legal course of action against the perpetrator. So this is where things get a little tricky. Because in the case of a repressed memory, one could argue the ordinary statute of limitations to bring a case against the alleged abuser should be suspended with delayed discovery. Because if a memory has been repressed, the individual could not possibly have been aware of it until something triggers it. Until something triggers it. And that could be 2 months later, 2 years later, 5 years later, 10 years later, in some cases 20, 25 years later. Should these laws, these legal doctrines be permitted in the case of repressed memory, when scientifically there's so much controversy about its validity? So I've given you a few links here on slide number 12, and I want you to take a look. One is specifically about the statute of limitation as it applies to child abuse. This is from a website of a law firm. What is the civil statute? Civil cases allow you to bring a case against someone who's harmed you, tort law as it's called, for suing for damages. What is the civil statute of limitation, sex abuse and rape in my state? And you can look on here. What happens if the abuse occurred 30 years ago? How do I know what the statute of limitation is? And you can look on here state by state by state, and you can find out what each state allows and doesn't allow. I also have given you a link for, let me see here. I have also given you a link, I'm just opening it myself. Hang on. From the National Conference of State Legislatures, state civil statutes on limitations in child sexual abuse cases. And this tells you the time within which a lawsuit can be initiated by a person who has been abused, a victim. And again, if you go down, you can look state by state by state. You can find New York on here. You can find a different state if that's where you're from or just because you're interested. And you can find what the law says about the statute of limitation for child-related sex abuse. So I want you to look at these because I want you to look at what the law says about the statute of limitation. And then I want you to think about whether repressed memories should be allowed to suspend that time frame and allow a case to be brought after the statute of limitation, so delayed discovery, in the case of a repressed memory, or do you think the science indicates it's far too controversial to do such a thing legally? Now, here's another problem layered on top of things. Courts are wildly, wildly, wildly inconsistent about the admissibility of a repressed memory, meaning some courts allow it and some courts don't. Some will admit the evidence and extend the statute of limitation to accommodate it. Others will disallow the evidence, siding with science, siding with experimental psychologists, saying, look, we don't know. The consistency of these things across different studies seems to be questionable. And so we don't think there's enough evidence to support, to substantiate these repressed memories. We're not going to allow it. The controversy and disagreement within the psychology profession, psychological science, is mirrored by the same kind of inconsistency in the court. So what this means is, depending on what state you live in, and even within a state, depending on what jurisdiction you're in, you might or might not be allowed to put forth repressed memory as evidence against an alleged abuser. So I want you to really think about that before you move on to the next slide, which is slide number 13. I want you to watch, I mentioned the George Franklin case at the beginning of this lecture. I gave you a very small snippet video just to get you thinking about the issue. But now I want you to take a look at the link I've given you on slide number 13. Because in this video, and I tell you how far to watch, up to 11:55. In this video, Dr. Elizabeth Loftus is an experimental psychologist. Her viewpoint about repressed memories and false memories are pitted against somebody by the name of Lenore Terr, who is a clinical practitioner. And in this video, you can see the very different perspectives of the clinician and the experimentalist. And I want you to listen to them and think about which of these two individuals, which of these two professionals you think has a more valid, more persuasive argument. And if you had to choose which of them should testify in a repressed memory case where someone is alleging abuse that occurred years before, would you A, pick Dr. Loftus and why? Would you B, pick Lenore Terr, practitioner Terr, and why? I don't think she's a doctor. I think she has a master's level degree. Would you pick her and why? Would you pick both and why? Would you pick neither and why? I want you to really think about that. Now, more recent research, 2016, by Dr. Julia Shaw. Interesting question she asked experimentally. Can people be made to believe they committed a crime and don't remember it? So, you know, one of the criticisms of the experimental psychology research on this issue is that it wasn't ecologically valid enough, meaning ecological validity refers to how similar the circumstances of a research study are to the actual real-world phenomenon it is meant to describe. Many critics of the experimentalists who have studied this phenomenon have said, look, these these experiments are not ecologically valid. They have people watch videos of car crashes and things, and that's not what happens in a crime. Something significant, something like being attacked or a crime, people might repress that because it's traumatic. So Dr. Shaw wanted to try to devise a more ecologically valid research study. She wanted to see if you could convince people that they committed a crime at an earlier point in time and don't remember it. So I have 2 links for you that I want you to take a look at on this video. I have a link that I want you to watch that's about 3 minutes long, Implanting False Memories, and I want you to watch the link after that on slide number 13, which is about 5 minutes long, Memory Hackers on NOVA. In both cases, you see Dr. Shaw explaining her research and what the findings indicate. And I want you again, after you watch these, to think about this question before you go on to our last video of this lecture series. I want you to ask, would you want Dr. Shaw to be permitted to testify in a courtroom, in a trial, wherein somebody is being accused of a crime or abuse or some kind of violence that supposedly took place years before, and the primary evidence against that person is a repressed memory? Would you want her to testify about her research? Why or why not? And I want you to think about that before you move on to slides 14 and 15 and the very last video of today's class. I will see you soon. Think about it.